When foreign investors establish a company in Vietnam, compliance is often viewed as a collection of administrative tasks. Submit reports, file taxes, maintain accounting records, renew licenses, and respond when authorities request documents. At first, this approach may appear sufficient, but over time, many foreign-owned companies discover something important. Compliance in Vietnam is not simply paperwork, it is an operational system. And if that system is weak, fragmented, or poorly coordinated, the business may eventually face serious risks involving audits, tax inspections, payroll issues, licensing complications, banking difficulties, or operational disruption. This is why experienced foreign investors increasingly focus not only on company setup, but on building sustainable compliance systems after incorporation. One of the biggest challenges for foreign-owned companies in Vietnam is that compliance problems often accumulate quietly. Monthly filings may appear completed, employees continue working normally, operations expand, and management assumes everything is functioning properly, but underneath the surface, weaknesses may already be growing. Accounting records may not align with operational reality. Payroll documentation may be inconsistent. Licensing obligations may be misunderstood, or supporting records may not be maintained properly. Because these issues usually develop gradually, management often does not recognize the seriousness of the exposure until auditors, tax authorities, banks, or regulators begin reviewing the company more closely. At that stage, correcting historical compliance weaknesses becomes significantly more expensive and stressful. Many foreign investors initially manage compliance in Vietnam through separate service providers. One company handles accounting, another manages payroll, a separate consultant assists with work permits, and legal support is only requested when problems arise. But in practice, Vietnam's compliance environment is highly interconnected. Accounting affects tax exposure, payroll affects labor compliance, licensing may depend on financial reporting, and operational records may later become legal evidence during audits or inspections. This means compliance cannot be managed effectively through isolated administrative tasks alone. It requires coordination across multiple areas of the business, and this is where many foreign-owned companies struggle. At LTS Law, we believe foreign investors need more than company incorporation support. They need operational clarity after setup. This is why our approach focuses on helping foreign-owned companies build compliance systems, not simply complete procedures. We help clients identify how accounting, legal, labor, licensing, and operational risks connect together. We assess where hidden compliance exposure may exist, and we help coordinate communication between the company and professionally assessed accounting, audit, and operational partners. Because in Vietnam, many compliance failures do not occur because companies intentionally violate regulations, they occur because no one was overseeing how all the compliance pieces fit together operationally. One of the most important foundations of compliance in Vietnam is documentation. Invoices, contracts, payroll records, tax filings, internal approvals, banking records, and operational agreements. Many foreign investors underestimate how important documentation discipline becomes over time. But during audits, tax inspections, labor disputes, or licensing procedures, these records often become critical evidence supporting the company's legal and operational position. At LTS Law, we help foreign investors understand where documentation weaknesses may create future risk and why strong compliance systems must be built proactively, not retroactively after problems appear. Many foreign investors assume hiring an accounting provider automatically means compliance is under control. But accounting is only one part of a much larger operational system. Strong compliance also requires proper labor documentation, licensing oversight, internal contractual structure, audit readiness, payroll consistency, and coordinated operational communication. This is why foreign-owned companies sometimes experience serious problems even when taxes were filed on time, because filing reports alone does not guarantee the underlying compliance structure is sustainable. At LTS Law, we help foreign investors evaluate compliance from a broader operational risk perspective, not only from a filing perspective. Many startups and SME foreign investors entering Vietnam understandably prioritize cost efficiency during the early stages. As a result, compliance functions are often fragmented across multiple low-cost providers, with limited coordination. At first, this may appear economical, but over time, hidden risks begin accumulating. Different providers may not communicate with each other, responsibilities become unclear, compliance gaps remain unnoticed, and management receives incomplete visibility regarding operational exposure. Eventually, problems emerge during audits, tax inspections, banking procedures, or expansion planning. At that point, the company realizes the issue was never only accounting or licensing. The issue was the absence of a coordinated compliance system from the beginning. Imagine a foreign-owned technology company operating in Vietnam for several years. The company grows quickly, new employees are hired, operations expand. Different providers handle different functions separately: accounting, payroll, licensing, legal matters. Everything appears functional during normal operations, but during annual audit preparation and licensing review, inconsistencies begin surfacing. Payroll records do not align fully with labor declarations. Certain operational agreements are incomplete. Supporting documentation is inconsistent, and accounting treatment creates tax exposure. Management suddenly realizes there was never any centralized oversight connecting the company's compliance structure together. What initially appeared to be isolated administrative weaknesses gradually becomes a much larger operational risk. This situation is extremely common among FDI companies in Vietnam. At LTS Law, our role is not simply helping foreign investors establish companies, it is helping them operate sustainably afterward. We help clients assess operational compliance risks, coordinate legal and accounting oversight, review documentation structures, support licensing and labor compliance, and identify potential exposure before problems escalate into larger operational or regulatory issues. Although LTS Law does not directly provide accounting or audit services, we help foreign investors identify professionally assessed partners experienced in supporting foreign-owned businesses with stronger transparency, responsiveness, English communication capability, and practical FDI understanding. Because sustainable compliance requires more than isolated service providers, it requires coordinated systems. Many foreign investors only begin paying serious attention to compliance after problems appear. An audit, a tax inspection, a licensing delay, or operational disruption, but by that stage, correcting structural weaknesses often becomes much more expensive and stressful. At LTS Law, we help foreign investors understand that strong compliance systems are not administrative burdens. They are part of protecting the long-term stability, credibility, and scalability of the business itself. If you are operating or planning to establish a foreign-invested company in Vietnam and want guidance on building stronger compliance systems, coordinating operational risks, or selecting suitable accounting and audit partners, book a consultation with LTS Law, because in Vietnam, successful businesses are not built only through market opportunity. They are also built through sustainable compliance systems behind the operations.